All right. 4, 3, 2, 1.
The clerk will call the court to order.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention. The court is now sitting. God save the state of Texas and this honorable court.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than admit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel. Of course, there may be glitches that will require patience. Otherwise, we will proceed in the same manner as we would in person. The arguments are being live streamed this morning, and a recording will be available later in the day. We're ready to hear argument in 19-694, N. Re C.C. from Denton County and the Second Court of Appeals District.
May it please the court, Ms. Draper will present argument for the relator. Mr. Haneke and Ms. Thompson will present argument for the amici. Relator has reserved 5 minutes for rebuttal. Ms. Draper will open with the first 10 minutes and will present the rebuttal.
Ms. Draper.
May it please the court. We are here today asking the court to protect what is arguably the most precious of our due process to the child shall always be the primary consideration in child custody cases. But as the United States Supreme Court stated in the landmark case of Truxel versus Granville, there is a presumption that fit parents act in the best interest of their children. That fit parent presumption is a constitutional due process right that must be the very first step of a trial court's best interest analysis. Do not let JD fool you into thinking this case is about the parental presumption found in Chapter 153 of the Family Code. It's not. The presumption in Chapter 153 provides that a parent should be appointed as the managing conservator of a child over a non-parent. If that were the issue, the father in this case already won, and we wouldn't be here because he was appointed the temporary sole managing conservator. The parental presumption in Chapter 153 does not prohibit a court from awarding rights or possession to a non-parent over the objections of a fit parent, which is what happened in this case. As such, the parental presumption and the fit parent presumption are two different standards. Both JD and the family law section have argued extensively that you should not grant mandamus because this case is a modification. A parent does not lose constitutional rights because he is involved in a modification rather than an original suit. The legislature recognized this when, in response to Truxel, it added the significant impairment requirement for grandparents and other relatives to Section 102.004 and 153.433 of the Texas Family Code, both of which apply in original suits.
Excuse me, Mr. Eichler. I have a question for you. Are you arguing that, in fact, the parental presumption cannot be overcome? Are you saying it's absolute? Or are you simply saying that it exists in a modification under the United States Constitution, but upon proof of impairment to emotional or psychological needs of the child, that it can be overcome? Is that what you're saying?
First, I'm distinguishing between the parental presumption and the fit parent presumption. But with the fit parent presumption,
I understand that. I'm saying that if we're not talking about the statutory presumption, we're talking about the parent presumption under Truxel. So under that fit parent presumption under Truxel, are you saying that it is an irrebuttable presumption that cannot be overcome? Or are you saying that it does apply, but with proof that the child will be emotionally or psychologically impaired, it could be overcome.
Your Honor, you broke up a little, but I think I got what you were saying. It is not an irrebuttable presumption.
Okay.
The burden should be on the non-parent to show that the parent is unfit. That threshold is already set forth with respect to grandparents and other relatives, which our legislature did in response to Truxel. And that has led us to a situation now where it is easier for non-parents like JD to get in the door and ultimately get rights and possession, such as happened here, than it is for grandparents and other relatives.
Then I have another question following up on that, and that is, if, for example, the fit parent presumption under Truxel has been overcome in a proceeding, and say 2-3 years later, a modification is filed, that presumption has already been overcome. Are you arguing that that presumption still remains in effect even though it's been overcome? Or are you simply saying that a modification proceeding exists if it has not been previously overcome?
There certainly could be situations where a previous application of the fit parent presumption should preclude a future application of the fit parent presumption. We don't want people coming back over and over and over having to litigate that issue, but that is not the case here, where there has never been the fit parent presumption applied.
And I understand that, but of course we have to look at other cases, so that's why I asked the question. Thank you.
I'm sorry, Justice, if you said something after that's why I asked the question, I did not hear it.
We have to look at other cases, and that's the reason I ask. I understand it does not apply here.
Thank you.
Would that serve as a basis for the distinction between VLK in this case, and how do you want to address VLK?
So VLK is very different from this case for a couple of reasons. First, VLK addressed the parental presumption from Chapter 153 as opposed to the fit parent presumption. The prior order in VLK was between a parent and a non-parent. It was not between the two parents. The parent in VLK who was involved in that order actually killed the original parent, so there was certainly a fit parent question to be had in that case. And the issue before the court in that case was whether or not the trial court erred in including a jury charge that said there is no presumption that a parent should be appointed as managing conservator if there has previously been an order of custody awarding conservatorship to a third party, or if the parent has voluntarily relinquished actual care, control, and possession of a child to a non-parent for a period of 1 year or more, which is clearly very different than what is happening here. Under the current state of Texas law, it is easier for a virtual stranger who happened to live in the child's primary residence for at least 6 months to get in the door on a custody case than it is for a grandparent or relative who has been actively involved in that child's life for years. That is exactly what happened in this case. In our first mandamus on the issue of standing, the Court of Appeals found that the maternal grandparents who were actively involved in this child's life since birth did not have standing, but the mother's short-term live-in boyfriend turned fiance did. Standing is one thing, but giving rights and possession of a child to a non-parent over the objections of a fit parent is another. This case is not about standing. This case is about making it clear that the first prong of a court's best interest inquiry must be the fit parent presumption, and if a parent is fit, the inquiry is over. The court cannot substitute its opinion for that of a fit parent. The record overwhelmingly supports that CJC is a fit parent, and JD has made no attempt to argue otherwise.
Excuse me, Ms. Draper, that seems to contradict what you had said earlier, that if the parent's fit, then the inquiry is over, because I think that then would make it irrebuttable. And you just acknowledged that upon proof of serious of impairment of a psychological or emotional nature to the child, that the presumption could be overcome. So I just want to that's the reason I've had some confusion in reading the briefs, because I don't think the inquiry would be over. It's certainly a burden to be overcome, but it doesn't end it, as you just said, correct?
So the constitutional protections provide that a presumption that a fit parent is acting in the best interest of their child.
Right.
If a parent is found to be fit, then the court cannot substitute its opinion for that of the parent. Here, we have the Truxel protections in the grandparent possession statute and in the standing statutes related to families and other relatives. And it required grandparents.
Excuse me, Ms. Draper. In Truxel, the court specifically used the words that the court must accord at least some special weight to the parent's own determination. And so that indicates that, in fact, the inquiry is not over once the determination is made that the parent's fit. It's simply saying that there must be some special weight given to that parent's decision regarding what's best for the child, correct?
I disagree, Your Honor. The court in Truxel was overturning a statute because the state of Washington gave no deference to the rights of fit parents whatsoever. It didn't address whether or not, the exact issue that you're discussing. The language that came up in Truxel discussed how the court cannot substitute its opinion of best interest for that of a parent.
So what did the special weight language mean?
In my opinion, it relates to the constitutional weight that the Due Process Clause provides to fit parents. There should be a very high threshold burden that a non-parent needs to overcome in order to get past that presumption and get to other prongs of the best interest inquiry. And I see that I am out of time.
Any other questions? Thank you, Ms. Draper. We'll hear from the amicus, Texas Public Policy Foundation.
Good morning, Mr. Chief Justice, members of the court. May it please the court, Robert Henneke on behalf of the Texas Public Policy Foundation. The correct outcome in this mandamus is for the court to affirm that the fit parent presumption is embodied in the best interest standard. The temporary orders here have divested the father, a fit parent, of possession and of full decision-making authority over his child. And we know that natural parental rights are superior under the best interest standard, nor are these parental rights created by statute, nor subject to legislative enactment. In fact, last year, justices on this court described parental rights as bestowed by our Creator, which are the very building blocks of our civilization. Now, there's two straightforward questions that resolve this case in favor of the petitioner. Number one, does best interest apply at temporary orders in a modification proceeding? Number two, is the fit parent presumption embodied in the best interest standard? Now, to speak to question number one, does best interest apply at temporary orders in a modification proceeding? The answer is yes. The statute says that it does. Specifically, Texas Family Code 153.002 says that best interest applies when determining all issues of conservatorship, possession, and access to the child. And also in Texas Family Code 156.006B and 101A address best interest when making decisions involving modification or temporary orders and modification proceeding. Now, best interest has been described in a number of ways. Yes,
Mr. Henneke. So thank you. The decision to introduce the stepfather in this child's life was made by a fit parent who is no longer
able to weigh in. But these are temporary orders, and so the trial court is faced with a decision made by a fit parent who is now deceased to introduce this stepfather into this child's life, and then and the biological parent. And so on temporary orders, why isn't it within the trial court's discretion to try to fashion a temporary order that honors the decision of the fit parent that's no longer there and work its way toward a final order that may be more restrictive, or that maybe says, this was a good decision, but it is no longer in the child's interest? Thank you.
The answer to that, Your Honor, is because even at temporary orders in a modification proceeding, the statute says that best interest is the main factor for the trial court to consider. And so the discussion should be then what encompasses best interest. And conceptually, best interest is based upon natural rights. And the trial court here erred when it applied best interest without incorporating the fit parent presumption. Now, to question 2, is the fit parent presumption inherent in the best interest standard? First of all, yes, it is, because constitutional avoidance requires that it be that way. And second, it's a constitutional natural law presumption. I think you can connect Truxel with the best interest standard in looking at 2 specific Supreme Court cases. One of those cases is Smith versus Organization of Families, where the Supreme Court, which was cited by Truxel, there said that the importance of the familiar relationship is in the role it plays in promoting the way of life through the instruction of children. And I also want to specifically point this court to Stanley versus Illinois, where the court held that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for the obligation the state can neither supply nor hinder. So it's a reciprocal right. It's a fit parent presumption relates to the constitutional rights of the parent, but it also relates to the constitutional rights of the child to be nurtured and cared for by their parents. And this court has an opportunity here to make clear that the fit parent presumption is embodied in the best interest standard, even if a non-parent makes it through the gate in something. Justice Lerman, to your question, sure, certainly it can be overcome, but it needs to exist there. And this court needs to affirm that when we're talking about the fit parent presumption, we're talking about the rights, we're talking about the best interest standard and vice versa. And therefore we ask this court affirm that the fit parent presumption, yes, Your Honor.
Excuse me, I'm sorry, but and that makes sense to me that yes, the fit parent presumption under Truxel would apply a modification, assuming it hasn't previously been overcome and entitled res judicata effect, but that it can be overcome by evidence of impairment to the child. And I think that's what you're saying, correct?
It is, Your Honor, and this court has the opportunity to recognize that best interest includes this fit parent presumption and to make that explicit. And with that, I see that I'm out of time.
Any other questions? Thank you, Mr. Hickey. We'll hear from the state. Ms. Thompson.
Thank you, Mr. Chief Justice. May it please the court, I'd like to focus on the distinction between standing and a right to relief. Even a party with statutory standing to be heard still needs to overcome the presumption that fit parents act in their children's best interest in order to obtain relief.
Ms. Thompson, may I just ask you, that sounds really good from a theoretical perspective, I understand, but what would be the point in allowing someone standing to get into court where at the end of the litigation, upon the same facts that were either agreed upon or proven, the parent would lose? How would that make sense?
I think Your Honor is looking at the difference between statutes where standing is predicated on overcoming the fit parent presumption by showing significant impairment, whereas statutes where that barrier has not been erected. Now, in this case, assuming JD has standing, which the court doesn't need to address that issue to decide this case. He had standing under a statute where the legislature has not erected that extra barrier. But the state, of course, is always free to provide additional protections on top of the Constitution. That's what the legislature has done at the standing stage. For instance, grandparents, in order to obtain access, would have to overcome the fit parent presumption just to be heard. Here, you can be heard and have statutory standing without overcoming the presumption. But in order to get relief, you still need to overcome it.
Do you think that, I'm sorry, Ms. Thompson, do you think that the fact that this is on a temporary basis has any effect on that? I believe that the Family Law Council filed an amicus brief indicating that, in fact, that standing was basically being ruled out through what the other side is requesting. So because it's a temporary case, do you see what I'm saying? And
yes,
so what is your response to that?
I think I understand the court's question, and I would certainly disagree that the parental rights are immaterial at a temporary order stage. Standing is a threshold question, and then temporary orders provide relief, even though they're temporary. Mm-hmm. You can think of it as a preliminary injunction in an ordinary civil case. So even if someone has standing, they still need to meet their burden to obtain a preliminary injunction or temporary orders here. So I don't think that the standing inquiry eliminates that. But in order to obtain relief here, JD needed to overcome the presumption that this father is acting in his daughter's best interest. Even a temporary deprivation of the father's constitutional rights is a serious concern and could lead to constitutional problems for the Texas Family Code. So the state would urge the court to explain clearly that the best interest of the child inquiry does incorporate the fit parent presumption where it's applicable.
So if the stepfather has not met his burden at the temporary phase, are you arguing that he would have an opportunity to do that again on final? Simply because there are things like, was a social study ordered? There's other evidence that needs to be developed throughout the process of a custody case that oftentimes would be very difficult to be ready within that first, couple of weeks in which a temporary hearing is typically held.
Yes, Your Honor. It is possible for a party to fail to overcome the presumption at the temporary order stage, but ultimately overcome it. To decide this case, it's sufficient for the court to grant the writ of mandamus and vacate the temporary orders. That leaves the trial court free to apply the correct standard of law, which includes the fit parent presumption. Now, this particular third party may have difficulty overcoming that, perhaps because of evidentiary issues that we see in this record, perhaps because of law of the case. But generally, that temporary orders are vacated doesn't mean the case is completely over. There's still an opportunity for a further showing.
Ms. Thompson, are there other presumptions that apply in an original suit that don't apply in a modification suit? And if so, the basis for treating this one differently would be your constitutional arguments, assuming those don't apply to the other ones, or what?
So certainly there are statutory presumptions that are different if we're in a modification posture as opposed to the original proceeding. And that's because once we get to modification, the best interest of the child is presumed to be maintaining the status quo. Now, typically in your mine run case, that will be custody by a parent or joint custody between two parents. And so then the child's interest in stability takes on a greater role. Now, that's not the case in an original proceeding, and it's certainly not the case where a new party has come in for the first time to ask for rights to that child. So even though the parental presumption as a matter of statute in Chapter 153 doesn't apply in 156, that does not mean that the best interest of the child doesn't include a fit parent presumption. Without some showing that this father is not acting in his daughter's best interest, the temporary orders are error as a matter of law. And there's no evidence in the record to support showing like that. I see him out of
Well, okay, go ahead.
Justice Lerman.
Ms. Thompson, I just have one question on that, and that is if there was substantial evidence enough to overcome the burden, say, for example, that the child's not having a relationship with the non-parent, and I don't necessarily mean in this case, but in future cases, would be so severe upon the child that that would overcome the presumption. You agree with that, correct?
Yes, Your Honor, there could be cases, certainly, where there is a showing made either at temporary orders or in final judgment that there would be significant physical, emotional impairment similar to what's been required by statute in addition to the constitutional right. And that could overcome the fit parent presumption. We don't have that in this case.
Right.
Any other questions? Thank you, Ms. Thompson. We'll hear from the real party in interest.
May it please the court, Ms. O'Neill will present argument for the real party in interest.
Ms. O'Neill.
Thank you. May it please the court. I want to make sure that we are focused on the right question today. The question before you on this mandamus of temporary orders is whether the trial court failed to correctly analyze and apply existing law. This court is well aware of the standard for granting mandamus, and that is whether there was a clear abuse of discretion with an inadequate remedy of law at law. And the trial court clearly abuses its discretion when it fails to correctly analyze or apply existing law. This court and other courts of appeals cannot substitute its judgment on the factual issues, so we focus on the legal question. So the question before you, whether the trial court in Denton County failed to correctly analyze and apply the law, is a resounding no. The trial court in this case followed 65 years of existing case law, beginning with the 1955 decision of this court in Taylor versus Meek. In Taylor versus Meek, this court held that the parental presumption is only one factor among others applicable to a suit for modification. Later in the 70s, the family code was codified and there was no specific parental presumption put in the modification statutes. Then fast forward to the year 2000. Following the Truxel decision, this court decided the BLK case, which again confirmed that the parental presumption is only one of several competing, even constitutional factors to consider in a modification. Incidentally, Governor Abbott was a justice on the court that decided BLK. Secretary of State James Baker wrote the BLK opinion, and our own Chief Justice Hecht was on the court that decided the BLK case without dissent. BLK has been the law of this state since the year 2000. And there is a long line of Court of Appeals cases that have underscored the BLK decision. Justice Guzman wrote in Ray Cam when she was on the Houston 14th Court in 2007. Justice Busby authored the Thornton decision in 2013. And important to the trial court in this matter, the Fort Worth Court of Appeals in PDM, and the Fort Worth Court of Appeals is the court of vertical stare decisis to the Denton trial court, authored the PDM decision in 2003.
Ms. O'Neill, may I ask you, does the brief that was, the amicus brief that was filed by the Family Law Council, which distinguishes between the parental presumption under our Texas statute and the parental presumption that's set forth in Truxel that has to do with the fit parent, does that distinction affect your argument in any way?
I think that the case law is not clear on a distinction between a parental presumption under the Constitution versus the fit parent presumption that the council discusses that's statutory. My opinion is that the statutory provisions have come along as a result of the constitutional presumption. And so I believe that they are enmeshed into the same, not necessarily a distinguishable thing. If you will recall, in Mays versus Hooper, In the year 2006, the Grandparent Access Statute did not provide for the constitutional parental presumption, and this court found the Grandparent Access Statute unconstitutional in 153-432, and which then led to the legislature changing the law and inserting what one would call the Fit Parent Presumption then into 153-432. So
let me just ask you real quickly. Let's say if the court were to determine that the Fit Parent Presumption under Truxel is different than the presumption in our family code that presumes it's in the best, that the appointment of a parent is managing conservatories in the best interest of the child, and Truxel has to do with parental decision making. If we did that, then would you still win?
Your Honor, I think that we win the mandamus because this is not the appropriate procedural time for the court to make new law. The court in BLK clearly said to the legislature, if you intend for there to be a parental presumption or a fit parent presumption in our modification statutes, then you need to create the law that puts those in there. In other words, further explaining the answer to your prior question, I believe that the fit parent presumption is a subset of the parental presumption constitutionally. I think that also on a modification, there are other competing constitutional factors. And this court has repeatedly held that the parental presumption is only one of those factors. The other factors are the right of a child to stability, the constitutional right of a child to the lines of affection that they have. So those are competing rights. There's also the constitutional level questions of res judicata. In other words, whenever natural parents can work things out among themselves, they do not need to seek court intervention. But whenever two fit parents, and I think the Family Law Council did a very good job of talking about this and talking about the Stillwell case, but when two fit parents cannot reach agreements, then they seek court intervention and they turn over to the court their constitutional right to make decisions on behalf of their children because they can't agree. And
so, may I ask you another question? In response to the excellent question that was presented by Justice Guzman that has to do with this, in this situation, the mother was a fit parent that was making the decision for the stepfather to be involved. So what is your response to that line of inquiry?
I believe that the mother was the primary conservator, and under the court orders, the prior court order, she was given the right to make those decisions. She introduced this gentleman into the child's life. He became a very important part of the child's life. In fact, the child called him Pops, and he felt that he was the child's stepfather. In fact, he was around the child more days and had more involvement than the father did prior to the mother's death. The father had less than our normal standard access schedule. He had 14 days in the summer instead of 30, and he had the every other weekend schedule that we are accustomed to. But
was he actually, excuse me, was he actually the stepfather, or are we just using that term colloquially? He had no legal obligations to the child, did he?
Well, a stepfather would not have any legal obligations to a child under any law. I believe that he thought he was the stepfather. He felt he was the stepfather. He was engaged to the mother, and he had assumed that role as stepfather, including taking the child to the doctor and helping care for the child on a daily basis. So I think your question may go to the question of the importance of the marriage ceremony versus the fact that they lived together. And I think that my answer would go to what is in one's heart. In his heart and in the child's heart, they felt that he was a parent-like figure. And a parent-like figure is one of the important distinctions that has been made even in the recent case of HS. I believe in your Justice Blacklock, in your dissent, you talk about where are the boundaries of a parent-like figure and where are the boundaries of the special weight that Truxel requires to be given to parents. And so
Ms. O'Neill?
yes, sir.
Justice Boyd here.
Yes,
So
sir.
why isn't the rebuttable nature of the presumption a sufficient avenue for you to raise all the arguments that you've just made about the stepfather and that relationship having been a closer relationship than the prior relationship that the father had? Why isn't that just something that can be used to rebut the best interest presumption?
Your Honor, I think the easiest answer to that question is that that is not the legislative scheme that we have been given. The legislature has told us that the modification standard is material change of circumstances and best interest of the child, or voluntary relinquishment and best interest of the child. And in this particular case, this was a modification of the prior order. The father sought affirmatively modification of the prior order. He affirmatively sought the court to appoint him as the sole conservator, which the court did on temporary orders. And the stepfather sought the modification standard of the prior orders to give him the access to continue the relationship of the child with the mother's household and affection that she had implemented. Unfortunately, the grandparents didn't have standing, and that is exactly a way of viewing this from the Truxel point of view, that our legislature has parsed out the small universe of people who are able to seek a modification in this circumstance. 156 provides that we look to 102 for those standards, and this gentleman, Pops, as the child called him, was one of those people in that small universe. The grandparents were not. The gentleman lived in the home for more than 6 months, had an extreme amount of contact with the child, and the Court of Appeals in Fort Worth determined that he had standing.
Right, but my point is, so statutorily, I mean, what I heard from Relators Counsel is that she's not relying on the statutory presumption. She's relying on a Truxel-based constitutional presumption that placement with the biological father is in the best interest of the child because of the biological nature of the relationship, but that she acknowledged it's a rebuttable presumption. So the fact that the child called the stepfather, quote unquote, called him Pops, and that they were close, and that the deceased mother wanted that relationship and introduced that relationship. What I'm trying to understand is why that's why the rebuttable nature of so can't you just go into that modification hearing and say, look, Judge, we understand that there's a presumption here in favor of the biological father, but all of this evidence, the Pops evidence, rebuts that presumption in this case. Why isn't that not the sufficient balance that recognizes and respects the nature of the biological relationship with the father on the one hand, given that you've got, understandably, you've got you do have a relationship there. It's different if the biological father never had any relationship whatsoever with the child. But why isn't that a proper way for the law to approach these types of cases?
Your Honor, first of all, there is no case that has ever held that the constitutional parental presumption is a rebuttable presumption in the best interest standard. There is no case that has held that. What the cases have consistently held from this court is that the parental presumption is one of many factors to consider in best interest. And I think that also it must be said and must be reminded that this is a temporary hearing. And I disagree with Mr. Henneke that the temporary hearing standard is safety and welfare and best interest under 105. And so the trial court has many competing things to weigh in a modification, even in a temporary orders on modification. I agree that
Ms. O'Neill, but It sounds to me like, in answer to Justice Boyd's question, you're simply saying that the fit parent presumption is not really a presumption, it's just a factor, but you don't deny it's a factor.
This court in VLK said that the parental presumption, the constitutional parental presumption, does not apply in modifications. This court in VLK said that it is one of factors. It said that in Taylor also. It is also.
So does that just come down to how much weight do we give it?
I think that comes down to how much weight the trial court gives it. Yeah. I think the trial court listens to the evidence, listens to the relationship of the parties, listens to the parents' particular relationship, and the status quo of the parents, and considers the right of natural parents in determining if there is a material and substantial change. The trial court also considers the stability of the child. The trial court also considers the love and affection that the child has from the competing parties. The trial court considers many, many, many factors, but what we cannot do, Justice Boyd, is prioritize the right of a parent over the right of the child. Those are two competing constitutional issues. And the rights of a child, both constitutionally and by our Texas Family Code, our Texas Family Code says that the best interest of the child always outweighs all of those other factors.
But the argument on the other side is that the best interest of the child is in being cared for by a fit parent.
I understand that that's their argument, but as this court, I know Justice Guzman said it in the Enrique Cam case, we have said repeatedly in our case law that it is one of many factors. And the other factors have to be considered as well. The standard on a modification is material change of circumstances. And certainly the death of the primary parent is a material change of circumstance, at which point it puts the best interest of the child back in issue in front of the trial court. And the trial court hears the witnesses, hears the evidence, conducts a social study, for example, listens to the therapist, as it did in this case, and considers a lot of varying factors of evidence. The right of a natural parent is one of those factors, but our entire foundation of Texas family law it's founded upon the concept that the best interest of the child has to be the overriding consideration, not the best interest of the parent. And so when they say to you that it is a subset of the factors of best interest of the child, I agree with them. This court has clearly held that all the way from 1955 to the present. For 65 years, the right of a natural parent has been a factor to consider in the best interest. The thing that they are trying to get you to do is to elevate the right of the natural parent above the right of a child to stability and love and affection, and those are competing constitutional propositions. This court has consistently...
What your argument sounds like you're saying that you agree that there's a presumption that it's in the best interest of the child to be with the fit parent, unless evidence shows that it's not in the best interest of the child to be with a fit parent. And if that's the case, then there's no presumption at all.
I do not believe in a modification that there is a presumption, Your Honor. I believe that in an original proceeding, there is a presumption. And the legislature hereby adopting...
So does that mean that assuming that under Truxel and Gerald D. or all those different cases, Pierce even, assuming that there's a constitutional due process, substantive due process, which is where the U.S. Supreme Court has focused on this, assuming that there's a constitutional presumption, it'd be your position that constitutional presumption in favor of the best interest of the child does not apply because it's a modification?
Yes, Your Honor, and I believe that that's what the precedent of this court has consistently held, that the original suit is where the parental presumption is determined. And then when a modification suit is filed, the prior order is res judicata as to that parental presumption, and the parties have given.
Ms. O'Neill, is there a res judicata issue here, though, since JD was not a party to the original Chapter 153 proceeding?
I believe that you're raising a privity of parties question, and that does seem to be a distinguishing factor between many of the cases. However, if we look to, for example, in Ray Cam, the facts in that case were very similar to this. The grandparent was not a party. If you look at PDM particularly, which is the vertical case to the court in this case, in PDM, the grandparent was not a party, and the court clearly said that it is not the identity of parties that determines the res judicata factor. Rather, once the custody is determined, then the parental presumption does not apply to subsequent proceedings regardless of parties. And this court,
the parental presumption was never an issue. Excuse me. The parental presumption was never an issue in the original case because the parties were the parents. There's never been a finding that it would overcome the parental presumption.
Well, the original suit, by virtue of the fact that it did not give the father primary custody, overcame his parental presumption. It gave him access and less than standard access. And so
when the suit is between the two parents, there has to be a decision as between the two of them. The parental presumption doesn't come into play at all in a suit between the two parents. So there's no res judicata effect when the court has divided custody between two parents as to the parental presumption.
I disagree, Judge Blacklock. I disagree that the precedent before us has not held as you suggest. The precedent before us has held that the parental presumption is determined in the original suit between the two parents, and that the parental presumption does not carry forward into the modification suit regardless of the privity of the parties. And the counsel
explain conceptually how the parental presumption, the statutory parental presumption, was decided in the original case between the two parents. How does that work?
Because the parties turned over to the court the right to determine the best interest. The parties could not, between themselves, determine the child's best interest. So the parties.
How is that the case, Ms. O'Neill? How is that the case when the parties entered into an agreed order? The trial court signed an agreed order for mom and dad. It appointed both parents joint managing conservators, and the possession and access order was a custom order that the parties developed and asked that the court sign it. So how in those circumstances did the parents turn over any decision making about the child to the court, given that they were not married and so went to the court to approve their custom agreed order and their joint managing conservatorship that they agreed to?
So in this case in particular, the prior order was not an agreed order as I understand it, but I think that you're asking me more of a global jurisprudential question. And I would still tell you that even with an agreed order, they're still submitting their dispute to the court, and they're still seeking government intrusion by the signature of a judge on that order. If they want to keep their stuff out of court and they don't want judges involved in their stuff, they have every right to keep that out of court as long as the two of them can make decisions together and not need court intervention. Courts intervene, and suits affecting the parent-child relationship were filed originally because the parents need a judge to oversee the best interest of the child. And so then, once that order is determined, we have relegated the best interest of the child to the court, to the government, to the state, and thereby taken away from the parents their natural constitutional right. And I want to make sure that we're talking about the constitutional right in the right terms. The constitutional right is the right of fit parents to parent without intervention. Without intervention. And I think that the other side, all of the parties to the other side, seem to forget that part of the constitutional right. It's the right to parent without intervention. And so the entire body of U.S. Constitution, U.S. Supreme Court law has come about because of government intervention. And the parties seek that government intervention by relegating the best interest determination to the court, to the trial judge in the initial case, whether it's by agreed order or contested order, it's still relegated and it's still subject to modification in the future. The modification standard is the material change of circumstances and best interest, with only one factor of those being the right to that.
And I guess, Ms. O'Neill, just as to that point that you just made, when you submit a dispute to the court, even if it's agreed, the courts do not have to accept your agreement necessarily if they find it's not in the child's best interest. And that's been a very, I guess, contentious issue over the years. Parents come into court because they need those orders for a lot of reasons, and yet sometimes courts refuse to accept what the parents have agreed to.
Right.
And that's problematic for a lot of reasons.
Well, for example, if there were domestic violence allegations, one of the questions in a prove-up of an original SAPSR is whether there was domestic violence, and if there is, the court doesn't have to accept a joint managing conservatorship agreement. So the best interest challenges are still submitted to the court, even if the parties attempt to agree. Most trial courts accept parties' agreements because that is the most efficient thing to do. And the best thing for the parties is to reach agreements, and the best thing for the courts as well. But it is still a relegation of their parental right to parent without intrusion.
No question here that the father's a fit parent, right?
I don't think that there has been a challenge to his fitness generally, but I think that there was evidence, I believe Justice Bland indicated kind of around this question about or maybe it was Justice Lehrman, I'm sorry, I can't remember now, about whether the absence of the stepfather would be injurious to the child. And I think the other side would probably argue there's a distinction in those two questions, whether absence of the parent is the issue or whether absence of the stepfather would be the issue.
Any other questions?
Yeah, I do, Chief.
Yes, Justice Black.
If the original case is between the two parents and one parent dies, why isn't the original case mooted, which is what would normally happen upon the death of one of two parties in a lawsuit, such that we should think of this new case as an original case to which the Chapter 153 presumptions would apply?
I think that there is precedent on that question that says that it is not mooted, that says that it is mooted maybe as to immediate possession, but not as to the court's continuing jurisdiction over the best interest of the child. There are numerous cases on that discuss the fact that the court continues its jurisdiction over the child regardless of the death of the parent.
Any other questions? Thank you, Ms. O'Neill.
Thank you.
We'll hear a rebuttal from the relator, Ms. Draper.
Thank you. May it please the court. Truxel tells us that a fit parent decides what is in the best interest of the child, not that it is a factor in the best interest of the child. It is not just one factor, it is the factor. It is a constitutional, fundamental right. Their theory on the other side allows Ms. Draper, if I may, what does a fit parent submit to the court for decision once it invites the court's intervention? So you said a fit parent decides what's in the best interest of the child. Once a fit parent comes into court, what exactly is it inviting the court to do? So when two fit parents come into court, they need help deciding, or they need assistance from the court in one way or another for a variety of reasons. But when two fit parents go into court, they are not giving away their constitutional rights with respect to any future non-parent down the road who's going to come intervene in the future. And the notion that that could possibly be the case should scare every fit parent. The theory of JD's...
Now, let me just say, at least our statute is more narrowly tailored. They're not giving away to any person that comes down the road, just a person who's had, the time frame of possession, care and custody. How does that impact your argument? Because it's not just anybody off the street. It's someone who's actually had, connection with the child. Thank you, Mr.
Yes, Your Honor. The standing statutes are more narrow than the ones in Truxel. However, as applied in this case, they did not provide any constitutional protections for the fit parents whatsoever. And unless we apply those constitutional protections as part of a fit parent analysis, then the father's constitutional rights are not protected in this case.
Ms. Draper, you mentioned the fit parent presumption from Truxel is the factor. Is that does your position entail that needs to apply in a Chapter 153 proceeding as well, and that is your position? Would it, if we agree with you in a 153 proceeding, would that mean that we would also have to apply the fit parent presumption there, and that you don't think that the statutory presumption on managing conservatorship is adequate to protect the constitutional fit parent presumption?
Yes, Your Honor. The parental presumption in Chapter 153 is not sufficient to protect the fit parent presumption. If that had been applied in this case, it would not have prevented the outcome that led to a non-parent receiving rights and possession over the rights of a fit parent. Opposing counsel has tried very hard to muddy the waters for the court today and to confuse the issues. This case is not about the parental presumption in the family code, and it is not an attempt to overturn VLK and years of precedents. This case is about the constitutional rights of fit parents to make decisions regarding the care and custody of their children. The father in this case is a fit parent, and as such, he gets to determine the nature of any relationship his daughter should or should not have with JD. The Constitution protects his right to make those decisions, and the trial judge abused her discretion when she openly substituted her opinion of best interest for that of the father's.
Ms. Draper, do we need Truxel or the Constitution to decide as a matter of law that unless there's a problem with the parent decides what the child's best interest is?
Truxel simply expounded upon the due process rights that parents already had. So this was a right that existed before Truxel, but this is a constitutional right that is as old as our country. It is one of the most important rights that we have. And
my question is, do we need the Constitution to play a role at all if we decide as a matter of law that parents decide what's in the best interest of their children unless there's a problem with the parent?
In this particular case, there's nothing in the family code that would say that. So without the constitutional protections, there's not any family code statute for the court to apply.
And there's a term best interest, and courts have to decide what that means. And if it means that parents decide unless there's a defect in the parent, then the Constitution wouldn't come into play at all, right?
The fact that the constitutional protections are so important and vital, I believe it's very important for the Constitution to be factored into that fit parent presumption and due process analysis, and realizing that it carries significant weight. It is not just one factor to be determined compared to, how long has a non-parent been in the life of the child, or will the child be upset at not visiting with a non-parent? This is a much bigger issue than that.
Any other questions? Thank you, Ms. Draper. The case is submitted, and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.